Let me start by thanking the CEU Alumni for inviting me to speak. The purpose of my talk is to share with you some initial conclusions and thoughts regarding the research that I've been involved in. And the focus of the research are legal restrictions on the use of commercial arbitration as a means of settlement of disputes in the countries of Central and Eastern Europe. The question I wanted to raise was to which extent arbitration is permitted or controlled or restricted in former socialist countries of Central and Eastern Europe, and whether and to which extent there exist similarities in the approach to commercial arbitration. In the geographical focus of my research were former socialist countries of Europe, from the Baltic to the Adriatic and the Black Sea, to echo the Churchill's phrase, generally the countries of what used to be known as the Iron Curtain. I looked at the legal restrictions which apply in those countries to the use of commercial arbitration rather than the use of courts for the settlement of commercial disputes, the limitations that apply generally, as well as limitations which apply to things like the choice of a certain arbitral institution or a place of arbitration or any other feature of the dispute settlement mechanism the parties wish to choose. No two laws of the region are exactly the same, but I found the laws concerned to be sufficiently similar to be for them to be meaningfully treated together for the purposes of the research. The analysis shows that many of the countries of the region provide for unusual restrictions, untypical restrictions to commercial arbitration. Restrictions which do not appear in the laws of Western Europe or in the laws of other developed countries, and restrictions which are certainly outside of the mainstream of international arbitration law today. Those restrictions can be compared to some restrictions which can be found in other countries around the world which also have a socialist legal past, such as, for example, in Chinese law. So I would submit that these limitations on the use of arbitration can be termed endemic for former socialist Europe. These restrictions can be grouped into three categories. One category comprises the rules which do not allow parties to agree to arbitrate certain categories of disputes. For example, in Lithuania, patent disputes are not arbitrable. You cannot refer patent dispute to commercial arbitration. In Serbia, disputes arising out of agreements on lease of real property also cannot be arbitrated. The second group comprises the restrictions relating to the choice of the place of arbitration. For example, in Bulgaria, two local Bulgarian companies cannot agree to arbitrate their dispute outside Bulgaria. A similar rule applies also in Croatia, where in certain categories of disputes, parties can agree on arbitration, but not outside Croatia. And then the third group of restrictions relate to the operation and establishment of arbitral institutions. For example, in the Czech Republic, the only arbitral institution, according to the Czech law, arbitral institutions can be established only on the basis of a statute of parliament, so only on the basis of law, which gives a privilege to the only arbitral institution which has been so established, namely the Czech Chamber of Commerce Arbitration Court. Similarly, in Hungary, no international arbitration can be administered locally on the territory of Hungary unless it's administered by the local Chamber of Commerce. At least some of these restrictions can be challenged on the basis of violation of EU law. at least some of them can be, are arguably inconsistent with the freedom to provide services under EU law. Some of them are also inconsistent with the 1958 New York Convention on Recognition and Enforcement of Arbitral Awards, which is a leading, a crucial international treaty in the area of arbitration. But regardless of that, these rules and limitations apply. They are applied by the courts, and they significantly impair the negotiations of arbitral agreements, the conduct of arbitral proceedings, and the enforcement of arbitral awards. I wouldn't like to paint too dismal a picture of arbitration in Central and Eastern Europe. By and large, arbitration law in the region is developed and supports the validity of arbitration agreements. But these exceptions, these restrictions present a considerable problem. They are difficult to reconcile with the liberal market-based approach to arbitration which prevails in Europe today. And I think the only explanation for them is that they are atavisms from the socialist legal past. They persist in the laws of several former socialist countries, even 25 years after the fall of the Berlin Wall. In order to understand these restrictions, we should consider the ideological and the legal approach to arbitration in socialism. And I think if we look at them from this perspective, they will be better understood. In socialist legal doctrine, arbitration was generally not accepted. There was a period initially, just after the First World War, a period of enthusiasm for arbitration, because in theory arbitration was interesting to socialist jurists because it was a non-state, a non-governmental means of dispute resolution. But with the strengthening of the state, it became ideologically unacceptable to allow parties to agree on the jurisdiction of a private tribunal and to substitute courts of law established by the socialist state with private tribunals. An important exception was international commerce. In international business, arbitration was allowed. In fact, it was accepted to such an extent that it was mandatory in business relations and business disputes between socialist countries. It was viewed as a lesser evil than having to submit to the jurisdiction of a foreign court. But this arbitration under socialist times was a very different animal than the private commercial arbitration that we have today. It was different in that only arbitral institutions established by the state could administer arbitration. Parties could not choose the place of arbitration. They had very limited autonomy with respect to the rules of procedure, and also the mandatory lists of arbitrators were used, usually providing for arbitrators of a local nationality. And in legal terms, these arbitral institutions were supplied with adjudicatory powers which were delegated by the state, and the arbitral institution, rather than the private arbitral tribunal or the parties, was in the center of arbitration law. All of this has changed after the fall of the Berlin Wall, when the countries of former socialist countries began to fundamentally reform their laws in order to adapt to the transition to a market-based economy. And a part of this process was a systemic overhaul of arbitration law in every single country of this region. Almost all of the countries shaped their laws in accordance with the UNCITRAL Model Law on International Commercial Arbitration of 1985, a leading legislative text on arbitration today. So the laws are completely new. They resemble Western laws, and in fact they are almost the same. as most Western laws on arbitration, and in substance they are almost the same, but still there are these important remnants of socialist law which can be found in many of the countries. Interestingly, there's little to suggest that these restrictions will be lifted in the future. In fact, in some countries there are new suspicions regarding arbitration. And in Hungary, which is the best known, though not the only example, there are new additional rules which restrict the freedom of parties to use arbitration to settle their disputes. As much as these tendencies have a new face, I think they can be associated with the socialist worldview according to which party autonomy in international business is all too often a byword for Western imperialism. There's a sense of suspicion that commercial arbitration, that's in party autonomy, simply abiding to the arbitration agreement can be politically and ideologically doubtful. I believe that these restrictions are one of the many examples of one of the many proofs that the deconstruction of the socialist legal order is far from complete, at least in many of the countries of the region, and that in many areas of the law, the process of the reform can be described by the phrase plus ça change, plus c'est la même chose. By way of conclusion, I would say that it's for each of the countries of the region to decide for itself whether or not these old restrictions can now be justified by some new policy. But at the very least, I think after more than a quarter of a century after the fall of the Berlin Wall, it would be appropriate to revisit these limitations on party autonomy and arbitration, and to ask exactly what is gained, if anything, and exactly what is lost by not allowing parties to resolve their disputes in the way they feel they consider appropriate. Thank you very much for your attention.